Listen to me, I said this is a real situation and the government has to do something about it.
What are you trying to insinuate? All these people looting Nigeria's money? You think
this is Nigeria Info, in the heart of Nigeria. 92.3, we are Nigeria Info.
Our freedom depends on our proactive responsibilities.
Let's talk, act, and be about development.
With one voice, our potential is realized. This is your number one news, talk, and sports radio station. 92.3 Nigeria Info. I am listening.
And now, Hard Facts.
Hard Facts with Dayo.
Welcome back. It is Hard Facts 90.3 Nigeria Info and Port Harcourt. I'm Dayo. 10 minutes gone past 4 p.m. Conversation does continue. Many thanks for staying tuned. Apparently, the drama playing out as far as the Sunday Igboho incident still has many twists and plots to it. It may take a while before we get to the end or some kind of climatic resolution of the situation. The latest in a series of twists and turns, or twisted tales, if you will, as far as the Igboho matter is concerned. Story here cut to the Punch newspaper. A DSS files remand application, asks court to cancel Igboho's associate's bail. Now, here's a bit of the story. The DSS has filed a remand application at the Federal High Court in Abuja, asking the court to nullify the bail earlier granted to 4 of the 12 detained associates of embattled Yoruba Nation agitator Sunday Adeyemo, aka Sunday Igboho. In the motion filed on Monday by the DSS lawyer Idowu Awo, the Secret Police urged Justice Obiora Ogwuche to cancel the bail granted to Amudat Babatunde, Abidin Shitu, Jamiu Oyetunji, and Bamidele Sunday. The DSS lawyer urged the court to remand the 4 detainees, quote, pending their arraignment during the court vacation. Now reacting, the lawyer to the detainees, Pelumi Ola Jengbesi, told the Punch that the remand application by the DSS was, quote, laughable. Also, he did say, quote, we've seen the new application filed by the DSS to continue the incarceration of innocent people that have been in their custody for over a month. It's laughable and turned logic upside down that after over a month in the DSS custody, the DSS still needs more days to punish them. I can assure you this will fail. End of quote. And the Punch earlier reported that Justice Ogwuche last Wednesday admitted the 12 applicants to bail after spending 5 weeks in the custody of the Secret Police following their arrest on July 1, 2021 at Igboho's Ibadan residence, raided by DSS operatives around 1 a.m. The Secret Police had also said it's killed 2 other associates of the activists in a gun duel and subsequently declared Igboho wanted for allegedly stockpiling arms to destabilize Nigeria under the pretext of Yoruba Nation. But the activist, who is now in a Beninese detention facility, had denied the allegation. DSS lawyer told the court he was not opposing the bail of 8 of the applicants, as their investigations revealed that the levels of their involvement in the offense of arms stockpiling and other criminal activities were minimal. Well, the DSS lawyer had argued that 4 others earlier mentioned should not be granted bail in the interest of justice and national security. Ola Jengbesi had, however, prayed the court to discountenance the argument of the DSS as it was unknown to the Nigerian law. Justice Ogwuche had disregarded our argument and granted the 12 detainees the bail. However, the bail perfection of the 12 detainees suffered a setback last Friday when their lawyer said he got to the bail office of the court and learned that the court required 24 shorties, which he said was in contrast to 4 shorties earlier demanded by the court. Let's discuss this matter. Can the DSS hold these persons in perpetuity for as long as they want, and several other matters related to this? I've got a guest in the studio, Barrister Festus Ogwuche is here. Hello, Barrister. Good evening. Welcome to the show.
Yes, good evening. Thank you for inviting me.
Let's start from the last part of this story I read just a while ago. The last paragraph, yes, I believe, yes, which goes, however, the bail perfection of the 12 detainees suffered a setback last Friday when their lawyer, Ola Jengbesi, said he got the bail to the bail office of the court and learned that the court required 24 shorties which he said was in contrast to foreshorties earlier demanded by the court. Can you help me make some sense of that situation?
Well, I'll just try, because it doesn't make any sense to me at all. What it means then is that the court had given the conditions for bail, and maybe the persons at the bail office added their own. I wouldn't say that the court later changed its mind to make it more stringent, because they are saying that 20 shortees are required.
But can the court do that? Can the court
cannot do that. It will only do that. It can only do that in open court if it wants to vary the bail conditions, and I don't think the court should be allowed to do that, because stringent bail conditions amounts to denial of bail. That's the substance of it, and I don't think the court will do that. So it's an issue that has to be answered, the question that has to be answered by those at the bail office of the court as to how they got to the figure of 20 when the court made condition for 4.
Now, back to the substantive issue.
Yes.
We may come back to this later on.
Okay.
But, or staying with it, rather, I think we should stay with it now. It reminds me of the situation with Ogwuche as well, when he was granted bail and allowed to travel out to seek medical attention. And I think it was Kaduna State government who added their own conditions as well.
Yes.
So is there a pattern here of sorts?
I mean, it's totally contrary to law. It's bizarre as far as I'm concerned. A court of competence has granted bail. So a lot of these things happening now, I don't know if the institutions understand the essence of their creation or what they are supposed to be doing in the first place. A court of competence has granted bail, and some other authorities there given its own conditions in addition to what the court has said. You cannot corrode up into the executive, of which those institutions represent, cannot corrode into the judicial institution to usurp its functions. It is the function of court. The court has exercised its function. Who are you now to add or to subtract? And that's exactly what's playing out in this circumstance when they go to the bail office and they say there are 20 witnesses are required, and at the end of the day, and the bail conditions were quite stringent, because I know that they faced a lot of difficulties to get them released since then. And they're very stringent. Now, the Supreme Court has stated in a wide reference of cases that, well, if you make bail conditions difficult, you'd rather say I refuse bail than to make it very difficult, because if you make it so difficult that the applicants or the person standing trial could not meet those conditions or fulfill the conditions, it amounts to that you've refused bail. So it has to be liberal, as much liberal as possible.
Is there a danger to this pattern?
There is a danger, because it now tends towards violation of fundamental rights, usurpation of the functions of the courts, and over-assertion of the institutions, particularly the DSS.
What if the state or the institution of government knows something that the judiciary does not know?
Come again.
What if the state knows something that the judiciary does not know?
No, it is for the prosecution to present it to the court at the appropriate time, at a point of bail. And by the way, it is not simply that, this person poses a danger, or he could be, he's a threat to national security. It's not sufficient for bail to be refused. For you to intimidate the court that, look, this man should not be granted bail, or if bail is to be granted, it has to be under very stringent conditions, and please attach these conditions to it. You must first of all bring your proof of evidence. You must file your information. On the strength of your proof of evidence and information, based on the facts, the proposed facts you're bringing to court, the court can look at it and say, well, this man should not be let go. But you cannot just with word of mouth come parading a murder charge or treasonable felony and all that. We have to back it up. We're backing it up with evidence, with facts, substantive facts, concrete facts, hard facts. These are what will make the court succumb to your opposition to the application for bail. Not just because this person is a threat to national security. How does that become a threat to national security? You have to bring the proof that he is actually that threat by the potency and quality of the information you file, and by the proof of evidence that you bring before the court.
So what's happened in this case, 12 persons involved filed a motion for bail. Court granted, the DSS did oppose, didn't have a problem with 8 of them being granted bail, but the DSS said that these 4, we don't want them to be granted bail. The courts did not listen to the DSS's position, wasn't convinced, I suppose, and went ahead to grant all 4 of them bail. Now, even in this particular instance, can the prosecuting or the arresting agency further processes saying, yes, you've granted them bail, but we still believe they should not be granted bail, and here is why we believe so? Is that unusual, or is it fine? Can they do that?
Well, they can do that, but that has to be by way of a sworn affidavit. And if they want to do that by a sworn affidavit, the affidavit must be strong. The depositions and paragraphs must show the strength of that affidavit and why that bail should be cancelled in terms of the conditions of the bail. First of all, these people are likely to violate, first of all, abscond bail, violate the conditions of bail, that this other person had applied for a visa to a particular country, and very likely he may disappear out of the frontiers of this country, or that look at what this gentleman has done to influence the court of prosecution or investigation of the case, or that his shorty cannot be traced, or all that. You can come by way of affidavit evidence to tell the court, but usually the only way you can do that is if you bring a very strong proof of evidence, or you file an information. That's a normal pattern that it is done. I don't think, I have not envisaged that it is possible that somebody who is on bail could ask that bail be discharged upon him on the basis of an application from the prosecution. I don't think that's the appropriate way to go about it.
So if there's a process like you've just described, does that mean that the DSS technically have done nothing wrong in this instance?
I wouldn't say they have done nothing wrong. It's simply that the way they went about it is laughable. I don't think that's the appropriate way to go about it. I'm yet to see a very strong proof of evidence and information filed before the Federal High Court to convince the judge that this should not be, or maybe the actions of the persons on bail, or maybe things they've done, things they plan to do, or any scintilla of evidence showing that these people are very likely to infringe the terms of bail. And these are the things that should convince the courts to cancel the bail. Courts don't cancel the bail anyhow. And it's not an application that should be granted as a matter of course. Even though it is novel, I wouldn't say it is out of the way anyway. But then it is then the responsibility of the prosecuting authority to convince the court adequately and properly, appropriately, that bail should be cancelled in circumstances that warrant the court to exercise its discretion in favor of that application. In circumstances that do not warrant it, for instance, if it is not shown that those people have done anything to influence the prosecution or to affect the investigation in an adverse manner or in a manner that is favorable to them, or that they are likely to abscond bail, which of course means that you're going to bring proper evidence to show that they are making plans to abscond from this country or to abscond to somewhere else where they cannot be reached, or they will tamper with evidence or whatever. Except in those very extreme conditions, the court is very, very unlikely to grant applications of that nature.
Now, I'm not aware that you work for the DSS, of course. I mean, it's called the secret police for a reason, so who knows? But we have had instances, so also I'm not suggesting or thinking that you are clairvoyant either, or that you know what's going on in the minds of the DSS officials.
Yes.
But what do you think might be going on here? Because in the past we have had instances where the courts maybe even discharges the person of an alleged offense, or grant a person bail, and right as the person is leaving the court or even the court premises, the person is rearrested.
Yeah, they have fresh evidence in that circumstance, and they may want to charge him for different offences apart from the one that he was discharged or he was acquitted.
So they've done that in the past. They are known to do that. So that's one option they could have taken. Okay, fine, this person's have been granted bail by the court. So as they're stepping out, we can simply pick them up again.
Yes.
They could have done that. Why do you suppose they're not taking that option and then insisting that this bill be upturned or reversed, if you will?
I think we've gotten to a situation where some of these institutions, law enforcement institutions, anti-corruption bodies, will begin to advise their lawyers as to the proper mode of doing things. And probably because the courts pander to their interests, apparently, the AFCC, the ICPC, the DSS, well, sometimes the president, your president, has told the world that the courts are responsible for the rising corruption, and the AFCC and ICPC precaution tend to take advantage of that to do other things. But then they should. I think what is important is the backdrop, doing everything against the backdrop of the fact that there's that presumption that works in favor of anybody standing trial as an accused person in the court of law, the presumption of innocence. That in spite of all the array of evidence you have and everything, the court has not heard him. And there's very likely a disposition of the court to look at the issue of bail, not refuse bail unduly, because at the end of the day, it could be found to be exculpable, of the offense against him. So these are the issues, and these must meet certain standards. I think it's a matter of strengthening the institutions, but I also think also that maybe a lot of them are trying to meet up with certain expectations, which I do not understand, because I don't see how, for instance, those 7 gentlemen that were arrested at the church, was the church again in Abuja. Yeah. The courts had granted them bail, but they took them back. And I read them the next morning. It was at the magistrate court that they were granted bail. Why do that?
Now, you talked about standards a while ago. We have laws that clearly define how this thing should go, how the processes should go. And yet we have, agencies of government, the likes you just described, the anti-graft agencies, the secret police, finding ways to just contravene, to infringe on the rights of people and all of that. What is intrinsically responsible for that? This crass violation of the rights of citizens. Is it that the laws are not strong enough? Is it that the judiciary is not strong enough? How are they able to do that? What's responsible for that?
It's been there for quite some time, and I think the real factor responsible is the fact that the institutions themselves are weak. And there are some persons, for instance, the case of the Kaduna State government bringing extra conditions as attachments to the conditions for the grant of bail for Elusakin. There are other persons who are outside the box, controlling what is inside, so to speak. The institutions are not very strong and independent to operate on their own. If not, I don't think that should be the case of one bringing extra conditions after the court. That one is totally bizarre. I don't think that one has ever happened in the annals of our legal system. This other one of getting people arrested immediately they are released and applying for the remand of persons who are already on bail. It's not very new, but the modus operandi they are using is totally brand new. What you are learning every day, maybe it's innovation, so to speak. But some of these things are very recondite, and because they do not meet certain standards as far as I'm concerned. But you're just watching them. But then it tells me that also that the court should be very, very worried, because at the end of the day, a lot of this. Elusakin, for instance, stayed how many years in detention? Solitary detention with his wife. The court found at the end of the day that this charge is not necessarily proper before me. Look at the totality of evidence. I'm sure since then you've taken your time to look at it. Totality of evidence, even the one brought in by the 2 army officers, and you see all manner of loopholes and inadequacies here and there. But then the next day after he was discharged and acquitted with his wife, they said they had already filed a new charge. And they're even talking about going on appeal. Which kind of absurd procedure is that?
It is hard facts, 91.3 Nigeria info here in Port Harcourt, 29 gone past 4 p.m. DSS files remand application, asks court to cancel IGBOHO'S associate's bail against his barrister Festus Ogwuche. We'll go for commercial break. We'll return in a moment. Conversation will continue. And you're welcome to join in via the usual platforms. When we return, do please stay with us.
Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book
Power Solutions every Thursday from 1:30 p.m. to 2 p.m. right here.
Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817-001-8162. That is 0817-001-8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817-001-8162. That is 0817-001-8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817-001.
We give the evidence. Just to keep you informed.
News, weather. I get my information top of the hour every hour.
92.3 Nigeria Info.
And now, Hard Facts.
Hard Facts with Dio.
Welcome back. Still had Factor 90.3 Nigeria Info here in Port Harcourt. I'm Dio. 24 minutes ago before 5 p.m. The news update comes about 5. Before then, discussions continue. DSS files remand application, asks court to cancel IGBOHO'S associates bail. My guest still will be in the studio, Barrister Festus Ogwuche. Barrister, welcome once again.
Thank you very much.
You're welcome to join the conversation right now. Comments, questions, let's hear it via the usual platforms. We are live on facebook.com/Nigeria Info PH. Call the numbers 0817-923-0002 or 0003. Also 0817-923-0007. WhatsApp is on 0809-030-6416. And I think that's just about it. I think that's just about it. Once again, facebook.com/Nigerian for PH. A reminder to turn down the volume of your radio set once the call is answered. And do please keep it brief and straight to the point as well. All right, calls coming in a moment. I may have a question for my guest before that happens. Am I getting one right now? Okay, apparently I'm not. So, Barrister, over to you now. Is the court likely to grant the DSS's request? In what circumstances? Are there any circumstances? Okay, I'd like to rephrase that. Are there any circumstances in which the court would feel obliged to grant the DSS's request to rescind the bail granted those 4 aides of Sunday?
I've just stated that. I mean, the circumstances that, well, this would likely to abscond, the bail granted, probably the court acted out without jurisdiction. I don't think the DSS the prosecution can raise that, or that the prosecution of the case or the evidence, or probably.
But the DSS, in its initial quest to
that is the actual locus upon which they can raise those issues, because first of all they are bailable offences, whatever offence they've brought, and the lawyer from that report you read, he said the lawyer did not oppose the application but did oppose the one for 4 of them. Yes. And I think it is at that point that they should have filed a very strong counter affidavit and supported it with a proof of evidence and an information before court showing why the court should not exercise its discretion in their favor. But another thing I'm also looking at is the power of the DSSS to prosecute. Does the DSSS have the power to prosecute? Does it have prosecutorial powers? I don't think so. Well, we've not been hearing them going to court to prosecute. I think prosecution lies at the abodes of the police and maybe the AFCC, the ICPC, all those ones that are established under law. But the DSS, where does it have that power? Except maybe the lawyers are acting in their own personal capacity, outside the official capacity of the DSS. These are questions that need to be answered, because I'm just a little bit surprised that the DSS is now coming in to prosecute cases.
So can you hold that thought, please? We've got Marcus on the line. Marcus joins us from Transamadi. Hello, Marcus. You're welcome. Go ahead.
Hi, Dayo. How are you doing?
Very well. Go ahead, please.
All right, then. I think there's something I'm missing here. If I remember correctly, when the associates of Sunday were taken to court, the magistrate or the judge did say they had no case to answer, that the DSS did not bring enough evidence against them. I stand correct, but I think that's what I heard. So if that's the case where you've not brought sufficient evidence against someone, isn't it the right thing to do being to dismiss the case? Why would you now say they should not bail themselves for something they've been accused of without any evidence?
Marcus, I'm not sure where you got your information from, but I'm not aware that any substantive matter has been heard by the court, because usually court proceedings, the bail application would come before the substantive matter is being listened to, whether or not we can let this person go and then come to court from their home or wherever to stand trial. But Barrister, are you aware
at that stage, the court cannot go into the substantive issue or make any pronouncement relating to the strength or viscosity of the allegations against them. At the stage of bail, it's purely bail application that they deserve bail because they have they have the presumption of innocence working in their interest, and they will stand trial and they will bring credible surety to stand for them, and they will give them proper proof of their residential address and whatever their commitment to ensure that they come to court. So at that stage, I don't think the court will go into the nitty-gritty of the substantive suit to determine whether they are culpable or not, or whether the charge is strong or not. Now,
Marcus, are you clear on that?
No, just I'm not a lawyer, but so are you saying that someone can just arrest someone off the street, right?
Okay.
Take the person to court, then the judge says, "Oh, why did you bring this person here? You haven't got any evidence against this person." Okay, no problem. Bail yourself. That's how it works.
It doesn't really work that way.
Not exactly.
I don't think it works that way. Even in advanced systems, people don't just bring people to court. I think they have institutions that are responsible for that. The police, the EFCC, the ICPC, all the law enforcement and anti-graft agencies, they bring people to court, and at that particular level, at this level, it is assumed that the person must have committed something for him to attract these people bringing them.
I think we should just, Marcus, the point you're making is, I think that the issue here is you got some information that they have been tried, and the trial judge said they've committed no crime. But I suspect strongly that information you have is incorrect.
No,
there has been no trial at all where the court determined them to be innocent of any offences.
Exactly, sure.
I think that's the point.
So basically what you're saying is they went for a bail hearing. Is that what you're saying?
Absolutely. It was strictly a bail hearing.
All right, thank you.
You're welcome. So, John from Anakan. Hello, John. Welcome, John.
Yeah, good afternoon, Dayo.
All right, go ahead.
Yes, I don't know why our system, our government, if I may use the word, don't want peace to reign in this country. They don't want judiciary to operate. That determines who is guilty. It's not the DSS or the government or the citizens that determine who is guilty. If the court have said that this is a bailable offense, why are they coming again to argue after the initial, approval has been given that they should grant a bail? So I think our government needs to allow our judicial system to operate. Every time there are cases in the court, they come to determine who is coming. For instance, I see the case of Nnamdi Kanu. They came to decide which people that enter the court, to tell the court who is going to be to have access to the court premises to listen to what is going on. Is it the judicial? Is it not the court that's supposed to decide that, or is it the DSS or the government? Lawlessness begets lawlessness. The government are trying to not obey court orders. So how can there be people to obey orders from the court? So people became apprehensive, they are afraid because the government themselves are not obeying court orders. So if the government, our Nigerian government, want peace to reign in this country, they should allow court orders to operate. The moment there is a ruling from the court, they should take it like that. If they want to appeal, they should go and appeal, not to begin to create unnecessary pandemonium in the system, and you think that the people will not keep quiet. IGBOHO case, government have said, the court have said he has no case. They are now saying, no, he has a case to answer. They should prove it at the law court and allow them to go on bail. You know, so I want to see a situation where our government to allow judiciary in this country to be operating alone. There should not be any interference. That is my contribution. Thank you.
John, you're welcome. Great to hear from you as well. Remember, you can join the conversation via WhatsApp, also 0809-030-6416. Also via facebook.com/Nigerian Food Page. And via Facebook, Onisiaji4 goes, just imagine the agency that's made to enforce the law are not doing the contrary. The DSS should have been the court order first before going for an appeal. And via WhatsApp, why were those IGBOHO associates let off the hook initially by the magistrates? Because I think that was the point Marcus was trying to make. Barrister, help me here with the Marcus matter and this WhatsApp message. Has any substantive matter been heard in the court regarding the Sunday IGBOHO's aides?
No. The judge was looking at the charge before him, and by way of the proof of information or the proof of evidence and the information before it, and looking at it also from the point of view that these offences are available, and possibly for the fact that the accused persons had spent quite an awful length of time in prison custody. And I'm sure the court also looked at the circumstances of the arrest, the very excruciating circumstances upon which they were arrested. A couple of them were killed in the course of these arrests, and they went through very, very hard times from the reports we gathered from the newspapers. But the court exercised its discretion appropriately in the manner it did, because that was purely a bail application. It doesn't have to go into the nitty-gritty of their inculpation, the extent to which they are guilty or not. That one will be proved in the course of the criminal trial of the case, and it hasn't gotten to that stage. I think your friend Marcus is rather putting the cart before the horse by stating that the court said something like that. No court would say a thing like that. You don't just bring somebody, an accused person, today in court, and the court will say, oh, go, you don't have any case to prove. No. First of all, they consider the issue of bail if it is a bailable offense. If it's not one that is bailable, then the court will remand the accused person in prison custody. What do you call it here now? Correctional. Is it actually correctional? Correctional center.
So we got Michael from Omagua. Michael, you're welcome. Please go ahead.
Yeah, good evening.
All right, go ahead, Michael.
Yeah, please, my question is, DSS and the court, which one have the right to discharge or to bail? Because I don't understand when court gives a last verdict on a particular matter and DSS continue withholding the person. Is DSS now the court or the law? I don't understand. And this had always been the reason for every uproar and agitation you see, every creak and cranny, that no one wants to be law-abiding, even the in the so-called offices of the security. I don't understand. Is that how we are going to run this country? Is it wrong for somebody to know that he is wrong and realizing that he's wrong, taking a right step? Have Nigeria not yet know that they are wrong in how they are dealing and maltreating the citizens of this country? That they should turn around and take the right step and amend it wherever they have went wrong. I don't understand the country we are living. This is where we're going to continue. Okay.
Michael, great to hear from you. You want to comment?
I think it is very important to recognize that fundamental rights are very sacred. Freedom and liberty of Nigerians is very, very important. And It is the only thing that we can hold on to as humans. It is natural, it is basic, it's fundamental, it is inalienable, it is indispensable. A lot of the instruments of which Nigeria is signatory to the international world give guarantees of these rights. I mean, the primacy of these rights, the importance, the paramountcy of these rights. And that's why the courts, I like the way they're going about it. They are very much worried about these things. We are living in rather very strange times, I must tell you, Dio. But it's not like maybe one's going to be very confrontational about it, but it's simply that after all, the judiciary itself has also suffered a kind of, how do I put it, bull adventure, well, but you know, the government started with arresting judges and justices until the Court of Appeal sitting in Lagos said no. You first of all have to go through the constitutional process and all that. So I'm not saying that everybody's intimidated, but you cannot have a highly intimidated citizenry and expect that things will work out the way you want it. No, we don't go. Fundamental rights are very, very sacred, and the courts must be very wary in pandering to the interests of these institutions of enforcement, law enforcement.
Pardon me, if I may. How do we ensure that we do not continue along this trajectory? What is it that needs to be done? Because you talk about how the judiciary has comported itself well enough. But it has been alleged that on many occasions the judiciary does pander as well to these agents of government. We talk about, we commend the trial judge in the Elusakin case for letting him go. But then again, Elusakin spent years in detention. Now we realize eventually that it was for a matter that should not even have come before the court in the first place.
That's the point. It beats my imagination. And that's because the institutions are weak, they are not strong. If you have strong institutions,
which institutions
the governor of the state will not be there to dictate the terms or the conditions upon which a particular individual will be prosecuted.
In this case, which institutions are you referring to?
I'm referring to every democratic institution, including the judiciary and also the law enforcement authorities, the DSS, for instance. You know, it's the arm, it's our own FBI arm of government, G94 and KGB and what have you. And we know what should be their game in this circumstance. But they are beginning to wade so much into some of these matters that one will begin to think that there's more to it than meet the ordinary eyes. I think they have their own traditional abode, their own separate abode where they operate. And they've done a lot of work, intelligence work in Nigeria, and they are respected globally. Coming out to virtually use up the functions of the police may not be very well to the interest of its image in future.
We do have to wrap up the conversation. I'm not sure we have time. Okay, let's take the call. Please let it come in. I think we expect a call. So we've got Thompson on the line. Thompson, you're welcome. Go ahead, please.
Good evening.
Make it very quick, Thompson.
I think I'll get to the I've just said it all. Our institutions are weak. And one of the problems I think we have in this country is our judiciary. That institution, for example, is not strong enough. We have stronger people oppressing it. For example, there is a case study in River State between River State government and the teachers. They went to the court of the court that is in charge of dispute between
the National Industrial Court.
Yes. Now they have a case that's against the River State government. As alleged, I've not seen a copy of that case. But again, 2 days ago, we learned that the River State government went to that same court, obtained a judgment stopping our doctors from going to strike. So why are the courts? So why are that holding or covering their eyes not good enough to force the government to obey their court? And today the government wants that court obtain it and that judgment against this. Now the DSS have ordered, the court has ordered DSS to produce these people in court. They bluntly refuse. A part of the government. Then how do you now want a common man to now have his trust, put his trust on that same court? They will take laws into their hands. I wouldn't blame them for doing so. Thank you.
Absolutely welcome. And via WhatsApp, Basso from Port Harcourt goes, let's face it, it is a constitutional and structural problem in which the judiciary is very weak. This is the problem. I guess we'll have to wrap it up on that note. Thank you for joining the conversation, especially my guest, Barrister Festus Ogwuche. As usual, great to have you in the studio.
Thank you, Bayo. Thanks a lot.
Commercial break now. We've got the news updates. Top of the hour, 5 p.m. Discussions continue afterwards. And said matter, by the way, Boko Haram top commander surrender, asked Nigerians for forgiveness. Do you think they should be forgiven? When I return, please stay with us.